Hi everyone, Harry here to talk about that really novel effort in Ohio in which a private group, the Haitian Bridge Alliance, attempted to bring a criminal action against Donald Trump and J.D. Vance for all their statements, dubious statements about the eating of pets by Haitian immigrants in Springfield and the like, which statements did lead to a lot of mayhem and chaos and suffering in Springfield. 33 bomb threats to schools that had to be closed down, all kinds of stuff like that. But we talked about it at the time, and the first thing to note is people got it wrong. There is a special statute in Ohio that lets some private group, not the prosecution, the state officials, which are the prosecuting entity sort of in, all states, but in Ohio for certain crimes, and they are really minor ones, minor misdemeanors. An example, the paradigm is sort of you bounce a check. But anyway, a private person who has information can bring that information to what the statute calls a reviewing official. And the reviewing official can, if the reviewing official credits it, basically tell a prosecuting attorney to, bring these charges. So not 100% clear whether the prosecutor constitutionally must do as the court says, but it's a question we will not answer in this case because the effort has come to a quick end and a pretty rough one as well. So this group brought forward information, and the information was basically, they said all these nasty things about immigrants and conduct in Springfield, and all these other nasty things ensued. And as I pointed out at the time, there was going to be this, in a law student kind of professorial way, invoked the so-called Brandenburg test. And that is when certain words are so likely to cause imminent danger that they can be suppressed, notwithstanding the First Amendment. So in a sense, it was like shouting fire in a crowded theater was the theory of the plaintiffs. They shouted, "Dogs being eaten in Springfield," and it led to imminent harm. Okay, but the court didn't agree and, in fact, really have slapped around the Haitian Bridge Alliance. And the court said a few things in basically essentially dismissing the case. What they did is they passed it on to the prosecuting attorney. Do with this as you like. The same thing as if the people had brought it to the prosecuting attorney in the first place, which is something that happens every day. You can always do that. A private citizen bring information to a prosecutor's office. Anyway, the court gives this a real look, as they're supposed to, and they say first, Brandenburg. This is all speech by Trump and Vance, and it sure looks and feels like First Amendment protected stuff. And it's sure, they don't bottom line on it because they don't have to, but it sure seems as if it doesn't cause imminent harm. Remember, that's the Brandenburg test. If you tell people to do things and there's any kind of causal break, even a temporal break, that ain't going to count. That's not shouting fire in a crowded theater where immediately there'll be a stampede. So there's first that this is a wash in First Amendment interests, because we're talking about political speech on the campaign trail. And then second, really rough, they basically say, it's not clear that what they're saying is even true. So this, I will see whether it provides or the Trump-Vance campaign tries to use it as a shot in the arm. But the court can be construed as saying, look, it's very hard to prove a negative. So we don't have evidence, and the Haitian Bridge Alliance certainly didn't supply us evidence that proves the falsity of these colorful and incendiary allegations that Haitian immigrants are eating our pets. So that is a far cry, of course, from saying it's true or it happened. But for purposes of this lawsuit and the attempt by the private group, the Haitian Bridge Alliance, which is essentially an immigrants' right group. They're nowhere near close enough. So, basically to get to first base, it's clear, and I said this at the time, they would have needed really good facts that what they were saying was false. Shouting fire in a crowded theater is not a problem if there's a fire. So, it's the falsity of it. And then also that it is sufficiently connected to imminent harm to basically justify the damage to First Amendment values of suppressing speech, even if it's political. And the court, it's a few pages of a written opinion, and they really tell the Bridge Alliance, get out of here and get out fast. There's really no showing that your facts hold up at all, and you haven't begun to take stock of the First Amendment values that are here. So at the time, there were people who misunderstood and thought these guys had initiated a criminal process. They hadn't. Under Ohio law, what they had done is initiated a special process for special small crimes that gave courts as reviewing officials the possibility of serving something up for the DA to prosecute. Already a pretty extraordinary thing for private citizens to be able to do. But in this case, that much did not happen. Rather, their attempts to use and leverage that statute, and they named a number of these sort of small crimes that can be invoked under that statute, gets nowhere with a fair bit of criticism and even sort of disdain by the reviewing court. So that's the end of the road for this effort to invoke the unusual Ohio statute. And now whether anything arises out of all the Springfield goings on, which I think is extremely unlikely, will fall to the people to whom it normally falls, that is the elected or appointed officials who have the right to exercise government power to bring criminal cases. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.